In a major new ruling, the U.S. Supreme Court has just delivered a serious blow to the administrative state by eliminating the very framework which allowed federal agencies to basically interpret the law however they wish. Specifically, the U.S. Supreme Court struck down something that's known as the doctrine of chevron deference. It sounds a little bit technical, but in a practical sense, this one Supreme Court ruling, it eliminated the very core of the power that federal agencies claim to possess. But that power is no more. Moving forward, unelected bureaucrats over in Washington will no longer have the authority to make rules that then have the force of law. Let me explain specifically the background of this particular case, as well as what it means for common Americans like you and I moving forward. To start with, let's rewind the clock back to the year 1984. That was when a case called Chevron versus the National Resources Defense Council made its way up to the U.S. Supreme Court. Without getting too deep into the weeds of that particular case, the end result was that the 1984 Supreme Court, they ruled in favor of Chevron, and in so doing, they created a new administrative framework. If there was an ambiguity in a given statute, well, the courts, they would defer the interpretation of that statute to the relevant federal agency. In other words, quote, "A government agency must conform to any clear legislation statements when interpreting and applying a law. But courts will give the agency deference in ambiguous situations as long as the agency's interpretation is reasonable." In plain English, it means that an agency has to conform to the letter of the law, but if there was even a slight ambiguity in the law, well, they can interpret that ambiguity as they may, and the courts will defer to their expertise. The thinking behind this ruling was basically that experts should be the ones responsible for setting the rules and the regulations that pertain to their industry, since of course they know better than an elected official or a judge. This established something known as the principle of chevron deference, and it gave federal agencies a massive amount of power. Starting in 1984, agencies were now free to make rules which effectively, in relation to us common citizens, carry the same power as laws. And you better believe that federal agencies have used this power countless times over the past 40 years. In fact, if you dig through the reams of case files, you'll find that the chevron deference precedent was the most referenced Supreme Court ruling in the realm of administrative law. Since the year 1984, it's been referenced around 18,000 different times in other cases. And these have real implications for real people's lives, because it's exactly this principle which has allowed federal agencies to interpret laws and go well beyond the literal text of what the statutes actually say. For instance, as just one example of many, during the time of the COVID pandemic, OSHA, which is the Occupational Safety and Health Administration, they interpreted the Occupational Safety and Health Act of 1970 as giving them the authority to impose vaccine and mask mandates on American companies. Nowhere in the law, nowhere in the text of the law did it say that they can do this. Instead, if you actually look through the law, it said that OSHA can issue an emergency regulation if it was, quote, necessary to protect employees from a, quote, grave danger. Now, was the vaccine necessary? Were the masks necessary? Was COVID a grave danger to people in their 20s and 30s? Well, according to OSHA, the answer to all three of those questions was yes. And because of chevron deference, their opinion carried the force of law. Likewise, it was the principle of chevron deference which allowed the ATF, which is the Bureau of Alcohol, Tobacco, and Firearms, to expand the definition of what it means to be a quote-unquote firearms dealer. You see, according to the new definition, if you sell a single gun to your uncle or your aunt or a friend, you might be classified as a gun dealer subject to arrest without a proper license. Likewise, chevron deference is the reason why the EPA was able to decide that a puddle somewhere in your property was technically a protected wetland subject to jurisdiction under the Waters of the U.S. Act. Basically, for the past 40 years, the laws that come out of Congress, they are what they are and they say what they say, but chevron deference has allowed the bureaucrats over in Washington to interpret the definitions and the meanings of the words in the actual laws. And, well, for the past 40 years, if you challenged any of those interpretations in court, you would 99 times out of 100 lose, because the courts gave the discretion to the federal agency. However, that all changed with this latest ruling right here. You see, what happened was that back in the year 2020, a federal agency called the National Marine Fisheries Service passed a rule which forced fishing companies to pay for the cost of federal monitors which were assigned to their boats. Meaning, that if you ran a small fishing boat, let's say you were fishing for herring somewhere on the East Coast, well, the government was not only going to assign an agent to come onto your boat and watch you as you work, but you also had to foot the bill. And the cost of these government monitors was not cheap. It was upwards of $700 per day, which of course might be fine for a huge corporate fishery, but for small owner-operated businesses, well, it was enough to completely wipe out their profits. Now, the government agency behind this mandate, they claimed that the Fishery Conservation and Management Act of 1976 gave them the authority to charge companies these fees. But of course, as you likely guessed, it was not in the letter of the law. There's nothing in that law that said that they can charge this fee. Rather, it was this agency's interpretation of that law. And so, two companies filed two separate lawsuits against the government saying that these fees were illegal. These two companies, just for your reference, they were Loper Bright Enterprises and Relentless Incorporated, both of which are herring fisheries located on the East Coast. Eventually, these two cases were consolidated, and after about 4 years of legal back and forth, the U.S. Supreme Court took them both up, heard both sides of the argument, and they eventually ruled in both cases against the government. All right, just to pause here for a super quick moment. Listen, it's obvious that the financial system is not looking too great. After being pumped up with trillions of virtually free government dollars for many, many years now, well, the stock bubble might actually burst in the near future. And in that process, unfortunately, it could take away the nest egg of anyone who happens to be exposed to it. And so consider taking this opportunity to diversify into something which is beyond the grasp of Washington, D.C. and Wall Street, physical gold and silver. And the best company to use, in my opinion, is the sponsor of today's episode, American Hartford Gold, who, I should mention, is also my own personal gold and silver bullion dealer. And besides myself, they have thousands of 5-star reviews from other Americans, and they also have an A+ rating with the Better Business Bureau. And working with them is rather simple. They have a huge selection of coins, bars, and rounds to choose from. They have super friendly staff who you can call, and they can set up either gold delivery directly to your doorstep, or they can even set you up in a gold IRA. And then lastly, best of all, if you tell them the Roman sent you, they will throw in a free gold coin with your first qualifying purchase. So give them a call. The number is 866-242-2352. That's 866-242-2352. Or you can simply text Roman to 65532. I'll also throw a link to their webpage. It'll be down there in the description box below. The rulings were pretty much the same in both cases, and they split neatly along ideological lines, with Justices John Roberts, Brett Kavanaugh, Amy Coney Barrett, Neil Gorsuch, Clarence Thomas, and Sam Alito all voting to overturn the chevron doctrine. As a part of the majority opinion, which, just for your reference, was written by Chief Justice John Roberts, here is what it said, quote, "Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers anticipated that courts would often confront statutory ambiguities and expected that courts would resolve them by exercising independent legal judgment. Chevron gravely erred in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play." Then, in order to assuage the concerns from those who support the Chevron doctrine, Justice John Roberts, he wanted to indicate that this new ruling, it will not suddenly invalidate tens of thousands of past cases, but instead, it should be applied moving forward. Quote, "By overruling Chevron, though, the court does not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specific agency actions are lawful are still subject to statutory stare decisis despite the court's change in interpretive methodology. Mere reliance on Chevron cannot constitute a special justification for overruling such a holding." Meaning, in plain English, that this ruling will not suddenly turn everything upside down by rendering 18,000 plus cases invalid, but rather that moving forward, there will no longer be this deference to the agencies in terms of legal interpretation. It'll be the courts themselves that'll once again have the full authority to interpret the law, with judges being the arbiters of deciding what a given law actually means. And in addressing the criticism that judges are not subject matter experts, while the bureaucrats over in Washington are, Justice John Roberts wrote the following, quote, "Congress expects courts to handle technical statutory questions. Many statutory cases call upon courts to interpret the mass of technical detail that is the ordinary dyad of law, and courts did so without issue in agency cases before Chevron. courts, after all, do not decide such questions blindly. The parties and the friends of the court in such cases are steeped in the subject matter, and reviewing courts have the benefit of their perspectives. In an agency case in particular, the court will go about its task with the agency's body of experience and informed judgment, among other information, at its disposal. Meaning, in a practical sense, that the idea that judges are going to be flying blind is not true, given the fact that they can call upon the expertise of many different parties. In a separately concurring opinion, Justice Neil Gorsuch, he added the following, quote, "Today, the court places a tombstone on chevron no one can miss. In doing so, the court returns judges to interpretive rules that have guided federal courts since the nation's founding." And so there you have it. The conservative majority on the court, they put the decision-making power once again regarding laws back into the hands of the elected lawmakers, and if there's any ambiguity, that power now goes to the judges to decide what the law actually means. And indeed, shortly after this U.S. Supreme Court ruling was handed down, well, the lawsuits began to pour in, and some of them are beginning to prove successful. For instance, back in the year 2020, the Department of Health and Human Services, they interpreted the phrase "on the basis of sex" to actually mean on the basis of gender identity. And therefore, they expanded the protections of the Affordable Care Act to transgenders, meaning that doctors and insurers, they were at risk of having their federal funding pulled if they refused to comply with the demands of transgender Americans, despite the law not mentioning anything about gender identity or transgenderism. However, following this new U.S. Supreme Court ruling, well, a federal judge over in Mississippi, he put a stop to this new rule because the doctrine of chevron deference is no longer in place. Well, the Department of Health and Human Services can no longer make such interpretations. And this type of thing is happening at many other federal agencies as well. For instance, you have the Department of Education, which is now being challenged by those who are saying that they went well beyond their authority when they plan to forgive a massive amount of student loan debt. You have the EPA, which is getting challenged by those who are saying that their new rule forcing companies to capture 90% of their carbon dioxide emissions is well beyond the authority that they were given. You have OSHA getting challenged on their new climate-based rules, and so on and so forth. This is just the new reality. And again, this is all happening because the underlying legal framework that allowed these agencies to basically interpret the law however they want, it's been scrapped. Although, as to whether this is really a good thing or not, well, I'd love to know your thoughts, because there really are two ways to look at it. On the one hand, it might be true that some decisions regarding interpretation of laws is very, very technical. One example that was given during this particular U.S. Supreme Court case was trying to figure out whether an alpha amino acid polymer qualifies as a quote-unquote protein under the Public Health Services Act. Thousands of decisions like these require very specialized expertise, which might bog down the court. And so that's the argument for chevron deference. However, that specialized expertise can always be brought in as subject matter experts to the court, because on the other hand, moving forward, the decisions surrounding the interpretation of these laws will be made by people who have no vested interest, because the regulators at these federal agencies, who have been for the past 40 years charged with interpreting the statutes that limit or expand their own authority, is like having the fox guard the henhouse. Amazingly, very often, those bureaucrats expand their own authority. Who would have thought? On the flip side, however, federal judges, they are appointed for life, and they have to recuse themselves from cases in which they have either personal involvement or some kind of an interest at stake. Now, of course, no system is perfect, but just looking on the face of it, it would seem that the new setup would lend to less government overreach and less potential for corruption, even if it makes the whole process slower. But I'd love to know what you think. Is eliminating the doctrine of chevron deference a net positive, or is it a net negative? Please leave your thoughts in the comments section below. I will be reading them later tonight, as well as throughout the rest of the week. And also, as you're making your way down there to that comment section, consider smashing those like and subscribe buttons on your way so that this content can reach ever more people, so that they can know what's happening at the federal level. Because weirdly enough, with the abortion Supreme Court ruling, there was a media firestorm, even though, of course, that is important. But with this ruling, it pretty much fizzled out and was covered, I think, for a few hours, and that was it. That was it. It just went away, and I think very few people know about this extremely monumental decision that came out of the U.S. Supreme Court. So by smashing those like and subscribe buttons, you can make sure that more people know about that. And then second to last, all my documents will be found in the description box below if you want to dig through the details. And then lastly, if you'd like to get access to all these episodes a few days ahead of time, we publish them over on Epoch TV 2, 3, or sometimes even 4 days before we do on YouTube, just depending on our editing schedule. I have my lovely editor here standing behind the camera. She's giving me a look saying, oh, don't tell people about the inner workings of our editing schedule. Well, that's just how it is, depending on whether there's a weekend, a holiday, if there's a lot of technical 3D animation that goes into the work, well, it just takes a few extra days. So if you want to get access to those episodes a few days ahead of time, you can find it over on Epoch TV. We also have a plethora of great backlog content that you won't even find on YouTube because it was not published on YouTube because we weren't able to. So again, the link is right there at the top of the description box below. Hope you check it out. And then until next time, I'm your host, Roman from the Epoch Times. Stay informed, and most importantly, stay free.